Good evening. Today I'll be talking about Sikiri Vasu versus State of Uttar Pradesh case. Father of a deceased major in an Indian Army who had died under suspicious circumstances approached the Supreme Court. He contended that his son had been murdered, but the case was wrongly treated. One of the suicide by the local police. Thus he was aggrieved and dissatisfied by the investigation into the death of his son. He prayed, and the case was transferred to the CBI for investigation. Issues. Did the victim, who had been aggrieved by poor or improper investigation, will be conducted by the police or in their case, have a legal recourse to ensure the proper investigation? Yet, there was no provision of the CRPC which gives the magistrate the power to direct the course of investigation. Yet, in fact, under the law, investigation is solely the domain of the police, and the judiciary could not interfere in it. Thus, in the absence of such an explicit power under the CRPC, how could the magistrate ensure a proper investigation? To overcome this, the Supreme Court invoked the doctrine of implied power. The doctrine stated that when a power is given to an authority, it includes such an incidental or implied power would ensure the proper doing of that thing. Therefore, applied to this situation, it would mean that the magistrate found had the power uh, to ensure the registration of the FIR. Under section 153, 156.3, they also had the implied power to ensure proper investigation once the FIR was registered. This could not take the form of a monitoring of the investigation by the magistrate to ensure that the police was performing its duty and conducting a proper investigation. So, in cases where magistrate left out that felt that the police had not performed its duty of investigating the case at all, or had not performed it satisfactorily, he could issue a direction to the police to conduct an investigation properly, or could also monitor it, thus laying out the entire process to be adapted by an aggrieved complainant in the case of the failure of by the police to register an FIR. The court stated that such person could first approach the superintendent of police, say 156.3, 154.3, seeking registration of the FIR by an application by writing. The FIR was still not registered. That person could seek to the area magistrate an application under section 156.3 CRPC for the direction of the police to register the FIR. It was also noted that though the general rule was that the magistrate could not interfere with the investigation being conducted by the police, the rule did not apply to cases where the investigation was not being conducted. Direction of the court, magistrate could not direct the police to register an FIR and investigate a case, but also can monitor or oversee the investigation and ensure that it is being conducted in a fair and proper manner. Thank you.